Hello, everyone, and welcome to our weekly webinar. Happy to be here again this week. We have three presenters today in addition to myself. I will do a little piece here about New York State's new policy on the rights of employees to express breast milk. Then we have Janelle Doobie, an associate from our labor department in Syracuse, talking about unemployment insurance matters. And then we have a new face who I'd like to introduce to you, Callie Schreiner, talking about the WARN Act, also an associate here in the Syracuse Labor Department. And finally, Travis Tallarico out of our Rochester office, talking about some pending legislation. And so let's just get started here. So this is breaking news. This is about as new as we get. We just learned that late yesterday, the New York State Department of Labor did finally release its policy on the rights of employees to express breast milk. We had been anticipating this for quite some time. For those who regularly attend the webinar, we had one of our presenters, Stephanie Fedorka, present on this law just a couple weeks ago. So we're not going to go through in great detail about the law again, but I wanted to make sure that everyone was aware that the policy is now out there. It's available on the website of the Department of Labor. After I'm done speaking here, I will go ahead and put a link in the chat. But as you can see here on your stage, this is just on your stage, excuse me, kind of a stage, on your screen. This is just a screenshot of the first part of the policy. It's a two-page policy because it did just come out. We've had it less than 24 hours, so I haven't had a lot of time to really examine it. But what I do find interesting about it is that it's not written like the state's sexual harassment policy, which is a true model that has spots on it that says, insert employer name here and modify it for your workplace. This one, it appears the intent of this one is you use this exact policy. And if you look at the language of the statute, there's some support for that. So go ahead, I'll give you the link. You can go to the website, download it, but it should be inserted into your policy handbook and distributed on an annual basis. We may give a little bit more further detail about this in future webinars, but this slide, in fact, was just inserted into the presentation about 5 minutes ago. So we just want to make sure that we're on top of things. And as a reminder, today is June 6th, tomorrow is June 7th. That's the effective date for the amendments to the New York State law. So all of this is in effect starting tomorrow. Okay. Now, by the way, I realize probably can't get this out, distributed by tomorrow, but, just use your best efforts in that regard. As long as you get it out to your workplace in a reasonable amount of time, I think you're going to be all set. So that's all I have here on this new New York State policy. So with that, I want to turn it over to my colleague, Janelle, who will talk to you about something that almost every workplace encounters from time to time, I think, which is, you have an employee who files for unemployment, you don't agree, and you end up with an appeal. And she's going to talk you through what that looks like. Thanks, Janelle.
Yeah, thank you, Kristen. So as Kristen mentioned, every employer has dealt with this in some way, shape, or form. And I've recently been helping some of our clients with matters relating to unemployment insurance after an employee is separated from employment. So we thought this would be a great opportunity to provide a little crash course in how to navigate the unemployment insurance appeals process. So just for a little bit of background, employees who separate from employment may be entitled to receive unemployment insurance benefits. However, some employees may be disqualified from receiving those benefits for a variety of different reasons. Some examples of disqualifying reasons include the employee voluntarily quits, they are terminated for misconduct. Upon separation from employment, the employee is not completely unemployed, meaning they may be employed in a part-time capacity elsewhere. Some other reasons are that the employee fails to engage in adequate work search efforts, or they refuse a job that they have the requisite training and experience to hold. So that being said, if an employee applies for and is denied benefits due to disqualification, they then have 30 days from the date they receive notice of this denial to request a hearing before an administrative law judge. The purpose of this hearing is essentially to determine whether or not the decision by the Department of Labor was reasonable. And then similarly, if an employee applies for and is granted benefits, an employer can also contest that decision and request a hearing in front of an administrative law judge to determine whether their objection is reasonable. So the hearing is an informal proceeding where both the claimant, meaning the employee, and the employer have the opportunity to present evidence, including documents or witnesses that support their position. So at the hearing, the employee will generally present evidence that showing that they are entitled to receive unemployment insurance benefits. And then conversely, the employer will present evidence showing that the employee is not entitled to receive benefits. All testimony taken during the hearing is recorded, and either side has the opportunity to present documents or other physical evidence that they see fit. So based on everything presented at the hearing, the judge will decide whether the employee is entitled to or eligible for unemployment insurance benefits. The judge is employed by the Unemployment Insurance Appeal Board, and their job is mainly to just ensure that both sides have a fair chance to be heard and that they get a fair and impartial decision. So the hearing process is pretty straightforward. I've just been through it recently, and the judge will begin the hearing by identifying all of the parties to the hearing, and will generally just give a summary of what the hearing's about while the parties are there. And then the judge will ask questions of the employee, the employer, and any witnesses present for either side. If either side has brought a lawyer or representative, then the judge will allow the lawyer or representative to ask the questions. And then the claimant will also be allowed to ask questions of their witnesses, the employer, and the employer's witnesses. So everybody has an opportunity to ask any questions. At the end of the hearing, both the employee and the employer can give a closing statement summarizing their arguments and positions. And then at the conclusion of the hearing, the parties will generally receive the administrative law judge's decision within 3 weeks. And in that decision, the judge will set forth not only the decision itself, but also any facts found from the evidence during the hearing, as well as the reason for those findings. And then either the claimant or the employer have the right to request an appeal of the administrative law judge's decision. A request for an appeal must be made within 20 days in writing from the date that the parties receive the judge's decision. Any party that wishes to appeal the judge's decision must have both been present at the hearing, and also they must provide the reason that the party does not agree with the judge's decision. So once a party's request for an appeal has been received, the Unemployment Insurance Appeal Board will then send out a notice of receipt of appeal. And then each party has the right to request to inspect the hearing transcript, and then the opportunity to submit a written statement that lays out why either party agrees or disagrees with the judge's determination. So once a request to receive the hearing transcript is made, that request must be made within 7 days of the date the party received the notice of receipt of appeal. So they have 7 days to request the hearing transcript. And then once they receive the hearing transcript, they've got 20 days to submit their statement to the Unemployment Insurance Appeal Board. After both parties submit their written statements to the board will then decide whether or not to affirm or overturn the judge's decision. And then upon receiving the board's decision of whether or not they've decided to affirm or overturn the decision, either party can then request another appeal to the appellate division of the state Supreme Court Third Department. So everything we talked about up to this point happens directly through the Department of Labor and the Unemployment Insurance Appeal Board. So it's all at the agency level. And then once you get through that appeal through the Insurance Appeal Board, then you can go to court. And the third department is the court that handles those appeals of unemployment insurance matters. So a party must request an appeal in writing within 30 days from the date of the appeal board's decision. And this request for an appeal is made directly to the appeal board. And once you get to the third department, this is the last step in the appeals process and the highest portion of the appeals process. And that's basically step by step what you need to know when you're navigating an unemployment insurance matter that's going through the appeals process. All of this information is always readily available on the New York State Department of Labor's website. So feel free to check that out if you're dealing with an unemployment insurance matter. And then be sure to reach out to us in the event that you need help appealing and or opposing an appeal related to unemployment insurance.
Thank you, Janelle. Very helpful. Good basic information that every employer should be aware of. Before I transition to our next presenter, I wanted to address one of the questions in the Q&A, which I don't know if you guys all noticed, but the air outside of Janelle's window was very hazy. We're here in Syracuse experiencing quite a bit of haze and really, really bad air quality, due to the wildfires. I know we have people on this webinar from all over the place. I'm not sure if you're experiencing this in other places, but the question on the chat, a little off topic, but very timely, which is, with the current air quality alert, should we be doing or saying anything special to our employees who are working outdoors? And I think maybe you think about this in terms of other environmental issues, say, you have people working outside in the cold when it's, sub-zero. I'm not sure that there's an affirmative obligation to do something, but it may be a best practice to do so in order to, let people know that they need to take precautions. You are under an obligation, under OSHA, of course, to provide a safe workplace. You want to pay special attention if people come to you with accommodation needs. For example, employees with asthma, I would be very attentive to those concerns because there are, real health concerns with people being working out in this air quality with certain conditions. So so just wanted to answer that question because I thought it was a really timely one. I hope that's helpful, and I hope everyone else is keeping their lungs clear while this hopefully passes soon. So I'm going to move on to the next topic. So I want to introduce our newest member of our labor department here in Syracuse. So Callie joined us within the past few months. We're really happy to have her as an associate here at Bond in our labor practice. And she's going to talk to you about an article that she just wrote. It just came out today if you want to check it out. But it's about plant closings and layoffs under the WARN Act. So thanks, Callie. Go right ahead.
Thanks, Kristen, and hi, everyone. So as Kristen mentioned, today I'm going to talk with you about a recent decision out of the Second Circuit addressing the Worker Adjustment and Retraining Notification Act, which is more commonly referred to as the WARN Act. If you could just advance to the next slide, please. As many of you are aware, the Federal WARN Act requires employers to give employees 60 calendar days notice in advance of plant closings and mass layoffs. This requirement generally applies to employers who employ 100 or more full-time employees. As you can see in the chart, the New York WARN Act under the New York Labor Law, Section 860, is very similar to the Federal Act with a few minor differences. Under the state statute, notice must be given 90 days in advance, and also the state statute applies to employers who employ more than 50 or more full-time employees. For purposes of this case, the court didn't analyze the statute separately and explain that the WARN Act is more protective than the federal version, and therefore, when liability is found under the Federal WARN Act, there will be liability under the New York WARN Act. Next slide, please. So a little bit more about the WARN Act. The primary purpose of the WARN Act is remedial. The statute was adopted in response to the extensive worker dislocation that occurred in the 1970s and 1980s. During this time, many employees often lost their jobs without notice, leaving entire families in just devastating situations. The WARN Act was instituted to provide workers and their families some transition time to adjust to the prospective loss of employment and to find alternative employment or receive any necessary retraining. Under the WARN Act, a plant closing is defined as the permanent or temporary shutdown of a single site of employment or one or more facilities or operating units within a single site of employment. What we've discovered over time is that there's some ambiguity with respect to what types of shutdowns or layoffs fall within the WARN Act provisions. The Second Circuit case seeks to provide guidance as to the fact-specific analysis that must take place specifically when addressing the term operating unit as it exists in the statute. Next slide, please. So this case, Roberts v. Genting, was about the closing of the Aqueduct Buffet, which was owned by Genting New York LLC, doing business as the Resorts World Casino, New York City. The buffet was located inside the casino, which offered guests over 30 food and beverage options, including a food court, service and retail bars, 2 gourmet restaurants, a fast food venue, a coffee shop, and then the buffet. All the food outlets, including the buffet, operated under the casino's food and beverage department. An employee was initially hired by the casino and then assigned to a food and beverage service, and then to the buffet or another food and beverage outlet. Once assigned to the buffet, an employee generally would receive a schedule to work there for 1 or more 6-month cycles. The buffet also had a designated cost center in the casino's accounting system. Staff from maintenance and engineering departments repaired defective equipment in the buffet. Whenever an unsanitary incident occurred in the buffet, the casino's environmental services department would provide specialized cleaning services, and stewards who performed ordinary cleaning duties rotated through all of the food outlets. The buffet had its own managers, and non-management employees throughout the casino belonged to New York Hotel and Motel Trades Council, who is certified as the exclusive bargaining representative for non-management employees of the casino. The applicable collective bargaining agreement provided the same salary structure, job duties, and terms and conditions of employment, regardless of which food and beverage outlet an employee was assigned to at any given point. So at this point, you're probably asking yourself, why are we going into such extreme detail about the inner workings of a buffet restaurant at a casino? Well, it's because these minor details were what the Second Circuit relied upon when it analyzed the facts of the case and ultimately decided that the record could support both the employer or the employee's legal arguments. Next slide, please. So to give you a little bit more background on the closing that started it all, we'll begin with the events on January 6, 2014, where the buffet was closed down and 177 employees were laid off. These workers included cooks, food servers, food runners, bussers, hosts, cashiers, warehousemen, and stewards who worked in the buffet department or in roles supporting the buffet. The employer notified affected employees of their layoffs through letters dated that same day. Following the closing, the employees immediately filed a putative class action against the employer, alleging that in failing to give them notice, the employer violated the federal and New York WARN Acts. Both parties then filed for summary judgment, asking for the lower court to dismiss the case. The lower court granted the employer's motion, concluding that the buffet was neither an operating unit nor a single site of employment such that the WARN Act notification requirements were triggered. Plaintiffs then appealed to the Second Circuit, and in a 2-1 decision, the circuit court reversed the lower court's decision, holding that for purposes of the WARN Act, there were facts in the record that a reasonable fact finder could use to determine that the buffet was an operating unit, and therefore neither side was entitled to summary judgment. Next slide, please. At issue in this case is the term operating unit. Under the statute, the term operating unit refers to an organizationally or operationally distinct product, operation, or specific work function within or across facilities at the single site. Interestingly, in hearing the case, the Second Circuit solicited the views of the U.S. Department of Labor on the scope and meaning of the term operating unit. The Department of Labor submitted an amicus brief and took the position that the lower court erred in concluding that the buffet was not an operating unit. In determining what constitutes an operating unit, the Department of Labor explained that the critical factor is the organizational or operational structure of a single site of employment. The Department of Labor further explained that important factors relevant to the inquiry include applicable collective bargaining agreements, the employer's organizational structure, and industry standards of what constitutes distinct work functions. As part of its brief, the Department of Labor provided illustrative examples. First, the Department of Labor explained that if an automobile manufacturing plant has an assembly line which assembles cars, there may be groups of workers whose job is to put on doors or bumpers. The operating unit should be the assembly line, not the group of workers who perform the task of the door or bumper assembly. Furthermore, the Department of Labor explained that a company does not need to function independently to be considered an operating unit. This was an important point that the Second Circuit reiterated in its decision and felt very strongly about. And then the Department of Labor went on and just listed other examples of what could potentially be an operating unit. These included a data processing department, a housekeeping department, a clerical pool, and a product department. So then in its analysis, the court compared the buffet to these examples provided by the Department of Labor and explained that the buffet was arguably less dependent on the casino than perhaps an assembly line at the automobile manufacturing plant, and therefore arguably even more so an operating unit in terms of the statute. The Second Circuit then made it clear that there's no one-size-fits-all definition for an operating unit, and in determining whether an operating unit exists, there's no single consideration is dispositive. Rather, they held that it should be a fact-intensive analysis, giving equal considerations to numerous factors that potentially impacted the ultimate conclusion. And the Second Circuit then went on to practice what they preached and conducted an extensive overview of the facts, explaining how there was evidence to support both parties' arguments, and therefore it should be up to a jury to decide the issue of whether the buffet is an operating unit. Next slide, please. So I'd like to provide an overview of some of the factors that the court considered and how they explain these factors and how they explain that these factors impacted their analysis. So you'll see that some of these factors are the ones that I touched above in the examples. Next slide, please. So first, the court looked at the buffet's physical location within the restaurant and found that factors like the buffet occupied an area separate from other retail outlets. It did not share space with any other restaurants and had a single entrance for guests who had to pass by a cashier station before being seated by a host. And from the court's perspective, these factors were all supportive of the plaintiff's argument that the buffet was not an operating unit. But the court also pointed out that the buffet was not separated by walls or doors and could lead a fact finder to believe that it was part of the casino and not an operating unit. Next slide, please. The court also looked at facts regarding whether the buffet was a distinct experience. So the buffet, the only restaurant to operate on an all-you-can-eat basis in the casino was the buffet. There were some foods that were unique to the buffet. There were some foods that were uniquely prepared for the buffet, and the buffet's kitchen prepared the bulk of the hot items. But the court also found that there were facts supportive of the employer's position, such that there were certain cold items that were prepared at a central location. Some of the menu items were the same throughout all locations. The menu was ultimately determined by an executive chef that was responsible for overseeing all locations, and the food was obtained through a central location. Next slide, please. And finally, the court looked at staffing and hiring arrangements, finding that the facts supported both sides and they were relatively equally balanced. On the staffing arrangements side, the court pointed out that managers of the buffet's kitchen and front of house area worked there full time, had the buffet in their job titles, oversaw employee work schedules, and also that employees who were assigned to the buffet were assigned there for 6-month stints or more. Wages were allocated to the buffet's cost center, and buffet employees were not treated as interchangeable with other food outlets. So meaning that the casino rarely assigned buffet servers to work in either of its fine dining restaurants. But also the court pointed out there was an executive shift who oversaw all of the restaurants and determined which food would be served at the buffet, and that the collective bargaining agreement did not identify the buffet as a separate department, division, or unit. And then with respect to the hiring, the court found that many of these practices were supportive of the employer's arguments, since many of them were centralized in their structure. For example, applicants applied to a centralized HR office, not to a particular restaurant. After being hired, they were provided a common orientation, given a single employee handbook and a single culinary manual. And finally, the court even looked at the uniform structure, pointing to the fact that servers, cashiers, bus persons who worked at the buffets wore different color shirts than other employees. And they also looked at the fact that cooks, stewards, and hosts wore the same uniform throughout the casino, regardless of where they worked. So ultimately, as we know, the Second Circuit held that after weighing all these factual differences, the question of whether the buffet was an operating unit in terms of the statute was for the finder of fact, and therefore neither party was entitled to summary judgment. And finally, a key takeaway from this decision should be that when an employer is planning a layoff that will will result in a shutdown of a department, division, or operation within a workplace, they should seriously consider the WARN Act implications, particularly if the number of employees impacted by the layoff will meet the statutory thresholds or federal or state WARN laws. So thanks everyone for listening, and please let us know if you have any questions.
Thanks, Callie. Thank you so much. So one thing that jumped out at me when I was listening to that was that this shutdown was in 2014. So one of the lessons is that these are important decisions because litigation can then, haunt you for many, many years. And in this case, almost a decade. I guess who would have thought that we would be talking about the intricacies of a buffet in this way? But what's kind of cool about this work is that we get to see lots of different stories about different workplaces. So anyway, thank you so much. And we're going to move on to our final presenter of the day, Travis Tallarico, who is going to talk about the Grieving Families Act, which I understand is still pending, but we'll hear what the status is. Go right ahead.
Thanks, Kristen. And hi, everyone. Thank you as always for joining. So again, as Kristen prefaced, I'm going to be giving some updates to and an amendment that is currently being proposed by the New York State Legislature in relation to the Grieving Families Act, which had been passed by both the New York State Senate and Assembly back towards the end of 2022, but was vetoed by Governor Hochul. So if we hop to the next slide, we will get into this. So helpful here is going to be just providing a bit of background as to kind of where we're at with things. So on May 2nd of this year, a revised version of the Grieving Families Act, otherwise I'll just be referring to this as the Act throughout the presentation, was introduced to the New York State Legislature. And as I mentioned, the original version of the Act was passed both by the New York State Senate and Assembly in 2002, but was vetoed by Governor Hochul on January 31st of 2023. So from a general standpoint, the intent of the original version of the Act was to expand both the class of individuals who are able to recover under New York State's wrongful death law, and it would also seek to expand the categories and scope of damages that could be recovered through such a lawsuit. So the current status of New York State's wrongful death law limits those who can bring a wrongful death action to distributees as defined under New York State's trust and estates law. And the current law also restricts recovery to pecuniary damages, so effectively money damages, which is generally understood as medical expenses, which may have been associated with the decedent's care prior to death, funeral costs, and loss of services, basically their loss of earning potential, where a distributee could have received benefits of that person's income if that person was still alive. So the original version of the Act proposed expanding the class of individuals who could recover under a wrongful death claim to close family members, which was not explicitly defined under the initial proposed version of the Act, and also to allow for recovery of emotional and non-economic damages. So, for example, these would be damages to compensate for grief or emotional anguish for loss of love and companionship of a family member. And the original version also sought to expand the statute of limitations of New York's wrongful death law, which is presently 2 years to 3.5 years. So Governor Hochul generally was in support of the act, but she decided not to sign it into law due to some concerns related to ambiguity, primarily relating to what was a very broad and undefined scope of several portions of the act. Specifically, a few of those is whether the act would have retroactive effect into the definition of a close family member. And while not listed on the slide here, a significant concern has been in the concern or in the realm of medical malpractice. And I know Governor Hochul had suggested potentially including some sort of a cap of damages for those types of actions. I'll get more into a bit of the nuances as to that and towards the end of the presentation here. Next slide, please. So the newly revised version of the act has been tailored and attempted to address the governor's concerns in a few ways. So first, it did provide a specific definition of what a close family member is, and that's defined as the decedent's spouse or domestic partner, their issue or children, foster children, stepchildren, step-grandchildren, parents, grandparents, step-parents, step-grandparents, siblings, or any person standing in local parentis to a decedent. And local parentis means effectively somebody who is acting as a parent, but not biologically a parent. And then under the revised act, it would then give the finder of fact, so the judge or the jury, depending on if it's a jury or a non-jury trial, to determine if a close family member is actually entitled to recover based upon a fact-specific analysis of their actual relationship with the decedent. Now, the second point of clarification is it does identify, more specifically identify the types of damages that could be recoverable through a wrongful death lawsuit. These include funeral expenses, medical expenses, grief or anguish, loss of love, society, protection, companionship, and consortium, pecuniary injuries, which is already part of the current law, but now including loss of services, support, or diminishment of inheritance relating from the decedent's death, and loss of nurture, guidance, advice, training, and education resulting from the decedent's death. And finally, the revised version of the act still seeks to increase the statute of limitations from 2 years to 3 years. It was a 6-month reduction from the original proposal, and it does specify that it would have a retroactive effect, applying to all causes of action that accrued on or after July 1st, 2018, regardless of the filing date. So where things currently stand, so while there were some, kind of some tailoring of the law, it's yet to be seen if these will satisfy Governor Hochul's concerns and actually result in passage of the act. Now, we may be seeing a decision on this one way or the other soon, as the New York State Assembly has approved the amended version of the act, and with the New York State legislative session concluding later on this week, given that the Senate passed the original version, it would seem strange that they wouldn't pass a more tailored version. So it is likely this will be back on the governor's desk in the near future. Now, again, kind of going back to what I was saying earlier in terms of if the tailoring that was done will be enough to satisfy the governor's concerns, that's still very, very open for debate. There's been a significant pushback specifically from the medical community on this because the potential scope of damages here could be very significant. And also an issue too is, with some wrongful death actions, if there's, intent or recklessness, that could, just kind of from a general standpoint, provide a bit more of a common sense approach as to, why, the wrongdoing party might be subject to, kind of more punishment or anything of that nature. Now, with medical malpractice actions, those are generally speaking all sounding in general negligence. And so I know that was a concern the governor had of, not only maybe, kind of imposing a significant burden on medical providers, but also what the trickle down of that would be in terms of increasing insurance premiums, costs of healthcare. So it's yet to be seen. So stay tuned, and we may well have a decision on this in the next few weeks.
Thank you, Travis. And that brings us to the end this week. We are running a little bit shorter this week, but hope that's okay with all of you. And thank you all for being regular attendees to this webinar. Those who are new, welcome. Hope you come back. Hope this is helpful. We do appreciate when you fill out the surveys and give us ideas for topics. We're always looking for suggestions for topics. We try to keep it a mix of new developments as well as just sort of general topics that we think are just always in need. So thank you again, and we will see you again on a future Tuesday. Take care. Bye-bye.